I will entertain a motion at this time to adopt the meeting minutes from the January 24th meeting. Senator McMorrow has so moved. Hearing no objection, the minutes are adopted. We're going to take up FOIA first. We will deal with our other bills that we had up in committee last time, a couple weeks ago. We'll take those up for a vote once we're at full strength and have full members. So I'm excited today to have the opportunity to start testimony on Senate Bills 669 and 670. These are the Freedom of Information Act bills that would finally bring the legislature and the governor's office under FOIA. I know for many people, we have been working on this type of legislation for a long period of time. And I even remember back in 2015-16, my second term, we had introduced a version of this. And then the next two gentlemen were our leaders from that point forward the term after that. And so pleased to invite Senators Moss and McBroom to the table here to provide testimony on the bills, and look forward to the conversation. So Senator Moss, Senator McBroom.
Good morning, Mr. Chair and members of the committee. This is always an exciting day for Senator McBroom and I, as we've done this multiple times over the years. In fact, I think I've calculated this is the 6th time that I've testified in support of our long effort to subject the governor's office and the state legislature to the Freedom of Information Act. Senator McBroom and I first started working together in drafting these bills back in 2015, but my involvement in this issue began long before that. I'd be remiss if I didn't recall back to my days at Michigan State University, where our journalism school director, the late Jane Briggs Bunting, created a very illuminating FOIA project for us as student journalists. She assigned each student in the program a county in Michigan to request mundane information, things like the SALT budget for the County Road Commission. And when we came back to class and reported our results, there were a variety of outcomes. Some students just got an easy answer. Some students were told they had to pay for that information. Some students were denied the request, and some students never received a response at all. So I understood then, from a journalist's perspective, if government can shield people from reviewing the SALT budget, what of more consequence might it be able to hide? And when I became a Southfield City Councilman, I understood the challenges of FOIA from a constituent perspective. The first month into my term, a resident wanted to get information about a development project in his neighborhood. And he got the runaround from a city department and then was directed to fill out a FOIA request and then got the runaround from that. It should have been an easy document for him to receive. He questioned why the city was preventing him from receiving information that should have been accessible. And he then came to every city council meeting thereafter to appoint himself as a watchdog and speak out during public comments. This was 13 years ago, and he still comes to every city council meeting. This is the background that I brought with me when I came into the State House, where FOIA isn't even applied at all. And I was relieved to find another lawmaker who was as passionate about this process as I was, and this has been a great partnership over the last decade, pushing this issue forward. For the last several sessions that we've introduced this, we've been able to push this further and further through the legislative process, and we start anew today. But I can acknowledge that the definition of insanity is doing the same thing over and over again and expecting a different result. This time, however, it doesn't feel the same, at least not to me, as many of the circumstances have changed. Primarily, we don't have the same obstacles in Senate leadership that we've had in the past, but a directive to move this forward. And we've all endured over the last several years here from this legislature ethical questions at best and criminal activity at worst that have made headlines across our state. Those actions from bad actors were only made possible by the dark areas in our law in which they could exist, chiefly among them that legislative records in Michigan never have to be made public. 48 other states in our country have figured out how to apply FOIA to their legislatures or their governors. We have to catch up to almost the rest of the nation, where journalists and residents alike can serve as watchdogs over their government. So before you is our package to expand FOIA with reasonable exemptions. We've been thoughtful and meticulous in how we've crafted it, and we've been bolstered by the support to get this done, namely from an odd coalition across the spectrum that has stuck with us along the way: the Michigan Press Association, the ACLU, and the Mackinac Center for Public Policy. So rather than prolong this intro, you can literally watch years of video of me talking about this if you'd like. I'm ready to kick it over to my colleague, Senator McBroom, and then we can field questions about what is in this legislation, how we intend to implement it, and how residents can utilize it.
Thank you, Mr. Chairman. Thank you, Senator Moss. As Senator Moss mentioned, it's been an interesting journey for us on this issue and the work that we've put in over the years. For me, it really started in my first term in the House when Senator Jim Townsend had a bill to put the governor subject to FOIA. And he was, of course, politically motivated to look for somebody in the majority to co-sponsor that with him, and he brought it over to me. And I was surprised to find out the governor wasn't subject to FOIA. And so, but I was wary. And so I checked around and asked one of my colleagues who had been in the House for a while about it, and he's like, oh, we introduced that when we were in the minority too. And there's a long history of the minority party introducing, well, not necessarily the minority, but the party opposite of the governor introducing that. And he's like, if you read it, you'll find it's just full of a lot of holes, and it's just kind of a press release bill. It's not a serious attempt at fixing this. And so I did that. I looked into it, and sure enough, the bill was, a good for a press release, but not very executable. And I started to think, well, why can't we get a bill that actually would function and be executable? And at the time, Rep. Townsend and I worked a little bit on it, but it was a big project for me as a freshman member. And so it took some considerable time and understanding to try to work something out. And fortunately, as time went on, there became more people interested in the issue and in seeing the legislature also subject to an Open Records Act. As most of you know, I introduced that with Senator Moss and a number of other partners in 2015 or 2016. I'm not sure. Was that term?
Around the same, yeah, 15, 16.
And I had developed something called the Legislative Open Records Act, which, as you know, Mr. Chairman, I still believe would be more resilient to constitutional challenges that I think may come in the future to just subjecting the legislature to FOIA. However, legal minds disagree. And so what you see before you, of course, is what we've always worked on for the governor's office, and now putting the legislature under FOIA, which I think the way it's written can function for quite some time before it starts to be nibbled away at and need other additional reforms. So I'm excited to see us try to be a trailblazer in this, because around the country, Open Records Acts for the legislature have typically faltered and been stymied by lawsuits and constitutional questions. And so I think that what we've crafted here can hold up, but it's going to take very careful implementation and execution as well. And so I'm happy to answer any questions you have, especially about how we came about to a number of these things, because the governor's bill is basically the same bill that we've been introducing since that time. The exemptions, initially governor's office proposed some 30 to 40 different exemptions, and I think it's down to 12. There's negotiations that happen, but I also want to say that for those who think, well, these don't go too far or they offer too many exemptions, that I think the most important step forward is to get something implemented, allow it to begin to work, and then some of you might still be here, some of us will be gone, but our successors, one way or the other, will have the time in the future to repair and improve and reform things as we see how parts work and parts don't.
Great. Thank you very much, gentlemen. First question, Senator McMorrow.
Thank you, Mr. Chair. Thank you, gentlemen, for bringing this forward for the 10th or 12th or 70th time. A question that I have is, I think, and you mentioned Jim Townsend, and when he was here before us, talked a lot about there's laws that we passed and then there's implementation and how things work. So as the both of you look around the country, which states stand out as kind of the best in class in terms of ease of use? Because there's, kind of the practicality of whether we subject the legislature to FOIA, and then is there a system that's usable? And do these bills address that implementation piece so that when we put it into place, it is easy for somebody to use or complicated? So the just general question, what states are doing it right? And knowing that we are currently at the bottom, where would this legislation kind of place us comparatively?
I can take a stab at that, and I don't have a state-by-state analysis per se, but there are a bulk of the states that have the legislative branch subjected to FOIA. A bulk of the states have the executive branch subject to FOIA. There have been challenges state by state, so some of these don't work as well as they could. But there are 2 states, it's us and Massachusetts, that have no protections. So rather than look at which states are doing it right, I think we recognize that we're doing it wrong. And so we created what would be a first 2015 lens of this and have updated it along the way. So, it's tough to compare state to state, but from what we've created and what we've even refined as recently as, this year, I think is going to be a leader, I hope, in the nation on this. We've had conversations from the start with our House business office. Now we've had conversation with our Senate business office. We want to implement the most current technology of tracking and tagging of emails. We want to, create a robust and effective FOIA department within those business offices. So, some of these laws have existed since the 70s. We are taking a fresh look here now in 2024 to create what we hope would be a leader on this. So I don't know, to answer your question, I don't know state by state, where things rank just because there are part-time legislatures and full-time legislatures, but we took into account everything here in Michigan, what has been missing, and looking at a 2024 lens of what would a FOIA of a legislature and a governor's office look like. And that's the product you have before you.
I think that, Senator Moss, at the end of his remarks particularly, point out one of the difficulties we've had when it comes to the legislative side of this, because a majority of the legislatures in this country don't meet as regularly or persistently as we do. And so some of them only meet every other year even. And the amount of legislative acts and things that they go through are so much smaller. And the tension, a lot of them are a little bit more homogenous in their partisanness than we are, where we're much more diverse in that. And so there's a lot less challenges in some states to their statutes. So the same statute in one state is working, whereas in another state it's been challenged and found unenforceable, which is frequently the outcome of these lawsuits against FOIA, against the legislature. They're rendered unusable due to separation of powers issues or violation of the speech and debate clause. And so it's a bit of a hodgepodge out there as to what individual states do. The states that meet less frequently seem to have more robust enforcement, but they seem to have less to enforce too. So it's difficult to say. As far as the governor's office goes, it's pretty standard. In fact, I think some of them are probably a little bit more robust than what we're suggesting, but we're the only state that explicitly exempts the governor. Massachusetts doesn't even do that explicitly. There's a lawsuit, a court case that has rendered that the fact, but in Michigan we actually specifically just say, and it's a bit of an interesting history if you go back to the 70s when we passed our Freedom of Information Act, how until the last minute in the Senate the governor was included, and then somehow or other some deal was struck and he was written out, and it's been that way ever since.
Yep, follow-up question.
Thank you. Senator Moss, you briefly mentioned it, but I think it's an interesting kind of administrative question, because yes, we are one of 12 states that have a full-time legislature, But because of term limits, which were recently revised, we have significantly more turnover in offices than many other states do. So for clarification, this is going to be administered by the House and Senate business offices, correct? Not individual offices.
That's correct. Just like a city or a county, there would be a FOIA department, a FOIA liaison. The person requesting information wouldn't interface with the member's office. They would go to the coordinator of this, and this office would be staffed. I mean, this has budget implications too, and we'll find out later this morning, how we can work with our appropriations team to ensure effective implementation. But yes, there's an intention, and in fact, it's written in the law that each chamber would have a FOIA coordinator, and the reality is it would be a staffed office so that they can field these requests and hopefully use the most current and applicable technology to achieve the requests that come in.
Thank you. Thanks for the work on this. I feel like that's a really important point, so we don't have Michiganders who make a request, and then by the time their request is received, that legislator is out of office, and then they never hear back. So I think that's an important piece for consistency. Thanks so much.
Great. Senator Lindsay.
Thank you, Mr. Chairman, and thank you, Senators, for testifying this morning. This is actually perfect because my question was about the FOIA coordinator for the legislative side. It looks like it's the majority leader and the speaker who are going to choose these. And, I didn't get to experience this, but I've heard from the current majority a lot of problems in the past that they face with the way the majority treated them. Now I do get to experience, how political it can be having a majority leader making decisions or their office making decisions. I mean, I don't wonder. This seems extremely like a bad idea to have effectively a partisan appointment over a position that's going to decide how we handle these FOIA requests. And it goes back to the story, Senator Moss, that you shared about your experience all the way back in college. It shouldn't be the case that when someone makes a FOIA request, the outcome and when they get back is in any way colored by what the politics of the situation are. And if we go through with this and this is effectively a partisan appointment, how do we prevent a situation where the person put in there to oversee this can say, well, we're going to make it more difficult for the minority than we do for the majority. It seems like it's a big concern I have. If you could speak to that.
Yeah, absolutely. A few things here. So right now, the directors of each business office is an appointment of the majority. It's been my experience that has had a less partisan lens in operating the day-to-day administration of each chamber, and that this FOIA coordinator would kind of be on that side of the administration of the legislature, not the political side of the legislature. A few other things, as we've discussed implementation, we've talked about opportunities for each caucus's legal counsel to have a role in the process to prevent politics from coming into play. And then because we are including the legislature into FOIA and not into a previous version that took us to where we are, the Legislative Open Records Act, the appeals process goes to court. So if somebody, like a journalist or a resident, feels that they were given the runaround, that they experienced a partisan bent on a denial, they can take that right into court, and the court will remedy the situation. So it's an added layer of a third party making a determination on what should or should not be subject to a FOIA request.
Thank you. Other questions? I guess I just have a few small things, just from an operational standpoint, just for people who might be watching here who haven't had a chance to read this. What types of documents are going to be applicable here, and what do you sense will be different for legislators' offices on what they need to do to be able to be helpful in this process?
Thank you, Mr. Chairman. So it comes down to it. It's fairly simple. I mean, we are looking really to be able to release people's official calendar schedule of who comes to visit your office. This is something that has always been very important to me as we've constructed this over the years. You often hear how many times somebody visited the White House. I think that it's much the same who's visited our offices. And if my citizens discover that a particular lobbyist has been in there 24 times in the last couple of months, I think they should be able to ask that question, how come you've met with that person so many times? So the official calendar is one big part of that. And the other is documents that are created as a legislator does constituent work. Not specifically the direct communications with the constituent, which of course are exempted from that. But when I have a constituent who comes to me and says, I'm having a big problem with MDOT or with the DNR or the DEQ, please advocate on my behalf. I want them to be able to follow up and make sure that I did that. I want them to be able to check up and make sure that I did somehow move forward on their issue. And not just claim that I did, but nobody ever got back to me or something. So this allows, I think, the constituency a way to verify the work that's been done. So those are the two main things that I've felt should be brought forward and be transparent about, and that aren't also our legislative work and process. Because as all of you know, when you're developing a policy issue, particular bills, there's a lot of back and forth and ideas that never should see the light of day, but are part of just kind of those initial vetting. And much like the exemption list for the governor's office as they prepare their budget, felt like those particular early on, back of the napkin scribblings that you get as you're trying to work out an idea shouldn't be exposed, because they're so prone to being weaponized in a political arena later on. Somebody has an idea, it's like, well, we could fund this if we cut all funding to state parks. And you're like, well, that's not a serious idea. Nobody's talking about doing that, but yet somebody might write that down as their offering in that discussion. And we don't want that kind of weaponization being available, especially in the partisan nature of the chambers.
And just
I'll also add, too, that correspondence between our offices and a registered lobbyist would be subject to disclosure. And so I think that's a key piece. I think the public would demand that, as well as the media course. So that's something that we wanted to keep as something that would be accessible upon request.
And then also emails, and I'm sure we'll have work phones that will now be text messaging would be also applicable here as well. Is that right? Okay. All right, thank you. Senator McMorrow?
Lots of questions. So I'm wondering if you could expand a little bit on the constituent communications piece, because that's something that my staff has elevated as a concern. We have some constituents, particularly who are in need of help, who will, as much as we might advise not to, send original documents, birth certificates, social security numbers. We wouldn't want to chill people from wanting to reach out to us when they need help. So I'm wondering if you can expand a little bit on that in terms of protecting constituents' information and their communication.
So, as I understand it, and as we've worked on this legislation over the years and talked to the business offices about how this would be handled, those initial documents that you receive, the letter itself from your constituent, that's not something that can be obtained. So it's simply not going to be something that the coordinator is then going to give to the media. If you do take some of that confidential information, though, and submit it to the various department, whether it's Treasury or something like that, then it's subject to the typical redactions that would be if they subjected it from the Treasury side, right? Because those documents are already available to FOIA on that side, but they would be heavily redacted for social security numbers, birth dates, driver's license ID, all of those things. So it would work much like you already understand FOIA as far as protecting that private information in that regard.
Yeah, this has been the most delicate balance of the whole project, I think, over these last 8 or 9 years. And, we have a variety of viewpoints, even from within the legislature, of legislators who feel that everything should be subject to disclosure, and obviously those who want to keep the most sacred constituent correspondence of those who reach out to us in dire needs private. In many regards, we are sometimes the last attempt to resolve an emergency issue, reaching out to their state senator or their state legislator, and it sometimes includes the most sensitive personal information, and we wouldn't want that to be exploited by somebody who's facing a crisis. So some of the language that we were able to land upon, again, I don't think we're ever going to find a perfect solution for this, but if it is your constituent and they contact you, that information is not subject to disclosure. And so it protects the ability for a constituent to confidentially share a crisis, an emergency, a gripe with their own lawmaker. And so that's where we landed. But again, some of the outcomes and some of the follow-up would be subject to disclosure. And one of the things that Senator McBroom talks about is we want to prove to our constituents we're doing what we said we would do. If we said we're going to follow up with Treasury, they ought to know that we did that. So it's a balance. I'm sure it can be scrutinized from every which direction, but over the course of the last 8 or 9 years, this has been a constant, and we're sticking with it.
All right, Senator Lindsay.
Thank you. I have a lot of questions about the exemptions on the governor's side. So many, in fact, that if I ask them, Mr. Chairman, you will cut me off. So I'm going to try to tackle it a different way and ask both of you, is it your understanding that if we move this forward, the governor is comfortable with the way we've structured the exemptions, or to what degree do you know? In addition to that, do you have any reason to believe that if we in this committee or out on the Senate floor, if we were to strengthen this, in other words, make fewer exemptions or narrow it in, that would make it unlikely that the governor would be comfortable moving it?
Yeah, so when we started this project back in 2015, we asked for feedback from Governor Snyder. And a bulk of the exemptions came from Governor Snyder's office. As Governor Whitmer took over, some of the other exemption requests came from her office.
We said no to some of them.
And we pushed back for both governors, a Republican governor and a Democratic governor. We've had a give and take. The governor, I think we all realize, has not publicly weighed in on this version, and we have been engaging with her office. This is something that is going to have to be a discussion for all of us to have. I'm been open to ideas to strengthen it, and if it can withstand scrutiny, let's move it forward. So this, as with any bill that you craft, you have to get the Senate to pass it, the House to pass it, and the governor to sign it in order for it to become law. We have to engage with her office on getting this past the finish line, and we have. So haven't heard a firm review of this particular proposal yet coming from her office, but this is a goal that she wants to achieve, and I'm open to ideas.
I would say, I think the list that we boiled down to in 2015 was 10. Might have been 11. It was 10 or 11. Looking at the list that we have now, the additional one is protecting the cell phone number of the governor and lieutenant governor. It's a issue regarding the release of civil action to the governor or lieutenant governor in which they're a party, but that's only prior to the final adjudication or settlement. So those are a couple of the additional ones that I see have been added by the current, requested by the current administration of us. And, I do have some questions and a few additional tweaks that I think Senator Moss and I have been working with the chairman about too, especially in regards to what it means for records created, prepared, owned, and used, but for less than 30 days. So I think there's still some improvement we can have and some things to talk about, but the list has been mostly unchanged over the last 10 years, and there's good reasons for these, protecting the information about the governor's residence, protecting information about the governor's security. These are protecting them when they're making a decision according to the Constitution about the dismissal of a judge or a local public official until that person has actually been dismissed. Because if they have found that wasn't warranted and they don't do that, we don't want somebody just dropping blanket FOIA requests to say, hey, who's all the people you considered in the last year dismissing from office? And then that becomes a weaponized political tool for somebody.
Senator Geis.
Thank you, Mr. Chair. And thank you, gentlemen, for getting us this far, finally. I do have a question regarding, our chambers, all 4 quadrants of the chambers have caucuses. And caucus is one of those spaces where things are discussed that are, central to our individual caucuses. And granted, 3 of us will not be here in 1,000 some odd days. But how will we prevent a future legislature from using caucus as a loophole to prevent the ability to have certain FOIA requests? Is there anything in here that we can do to make sure, to shore that up?
Well, I would offer to you, Senator, that it's not so much that we've created a loophole in the legislation regarding that issue as the Constitution itself guarantees us the protection that we typically call the speech and debate clause. And those documents within the caucus that they provide you, such as, this analysis I have here from my caucus about these bills, are part of that speech and debate, the policy development process that I feel like the Constitution makes clear provisions are protected. And so I think the statute is simply pointing that out. So, I hope that answered your question. If you're talking about something non-policy-wise that you want to talk about from the caucus document, that's different. But as far as that's what I'm thinking when you ask the question.
No, and I appreciate that. I just want to make sure that we aren't inadvertently creating the speech and debate clause notwithstanding, that we're not creating a space where a future caucus or a future legislative body might decide, like, this thing is now caucus privileged material, and then therefore cannot be FOIA'd.
I have a lot of concerns about both the legislative side and the executive side being able to label things. And you see that happen at the national level too, with presidents who say, this is executive privilege, you can't look at this, and then there has to be the adjudicative process to determine, is that properly labeled? Is that properly shielded under this provision, or is somebody trying to sneak it in the back door and call it something that it's not? I think that's very possible to happen here in the future, and it's something that, as Senator Moss referred to earlier, is going to have to go to the courts for clarity at that point.
Yeah, every version of our drafts over these years has included that provision of internal caucus documents reflecting the speech and debates clause. But again, if it's something that is an egregious attempt to just shield something that otherwise should or ought to be subject to disclosure, there would be an appeals process for somebody to engage in.
Thank you.
If I may, Mr. Chairman, I'd just like to put out there that I think it's important that we all recognize that while we like to think about this legislation as somehow going to end all corruption and, just bathe us all in wonderful sunlight and fix all of the problems, and no legislator or governor is ever going to try to skirt the rules again, that's really not what FOIA does. FOIA, open records, give reassurance as far as the ones who follow the rules already. And those of us who believe in doing what's right for the people, it gives them a chance to verify that we're doing it the right way. And occasionally here around the country or in your local community even, when there's mistakes made, it helps provide clarity of how we got where we're at. And we saw that happen with the Flint water crisis because Governor Snyder was willing to turn over everything, released all of those documents internally and gave them up for scrutiny. So that helped people understand, how did we get here? Was there malfeasance? Was it just simple neglect? What happened? But we're not going, ultimately legislators or governors who do want to skirt the law are going to find new ways to do it, unfortunately. And our successors are going to have to try and tighten things up at that point. But this isn't somehow going to make everything rosy forever more.
Yeah, I fully agree with that, and we often cite that 2015, which at the time that we drafted this was new, but this 2015 Center for Public Integrity poll that Michigan ranks last in terms of every state in the nation in ethics and transparency and accountability. And there are 13 categories, and under each category are a series of bullet points. This is one of many, and so it certainly is not the total sweep-all solution to reducing those instances of bad actors, but it is a great flashlight to expose some of the dark areas where too many have been able to operate.
Yeah, and I just wanted to add, again, reiterate what you had said earlier about the judicial review, which is what we see on the local level. For many of us, we came out of local government, and when a local government decides they want to prevent somebody from getting something, the courts have always been the way to deal with that. And we see on a very regular basis the press and others that will have to go to the courts at times to be able to move things forward. So I do think in hopefully these minor times when this happens, or a limited amount of times that it happens, having that judicial review is, I think, what is different now than maybe in some previous versions of all that. So, gentlemen, I want to thank you. I don't see any additional questions today, but I want to thank you for your testimony. We do have a number of people who would like to speak. First up is Lisa McGraw from the Michigan Press Association.
There we go. Good morning, Mr. Chairman, members of the committee. My testimony reiterates a lot of what the senator said. We've been working on this project, I'll call it, with Senator McBroom and Senator Moss for many, many years. I think I'm the lobbyist Senator McBroom was referring to when he said something about being in his office 24 times. We appreciate their long-standing belief that the governor and the legislature should be subject to FOIA in Michigan. As you know, Michigan consistently ranks poorly on measurements of transparency when compared to other states. The fact that our governor and legislators are not expected to be forthcoming with their documents is one of the main reasons for this. This is why the Michigan Press Association supports Senate Bills 669 and 670 as an exceptionally good beginning toward moving in a better direction. We do have some concerns and with regard to the exemption, and it's our hope that we can address these exemptions moving forward. And I'm going to outline real quick the four that are top on our list. We're concerned about the exemption for the governor with regard to decisions about granting or denying reprieve, pardon, etc., commutations. We're not really clear on why that's necessary, and are concerned about unintended consequences with regard to that. We're also concerned about the exemption for both bodies regarding the constituent communications to a point. We feel like the language is too broad and there are opportunities to narrow that a bit. Records created, prepared, owned, and used in possession of or retained by the state legislative public body for less than 30 days, which I think Senator McBroom mentioned. We feel that's very broad. And again, question the need. And records created, prepared, owned, and used in the possession of or retained by the majority or minority caucuses of each house of the legislature seems a bit vague to us also. We understand the need to protect the privacy and security of our elected officials and their constituents. I myself did constituent work back in the day when I worked in the Senate. Our concerns lie in the overly broad language of some of the exemptions, and we look forward to working with all of you going forward on some of that.
Great. Thank you. Any questions? Seeing no questions?
That was easy.
We look forward to continuing to work with you. Our next speaker is Steve DeLee from the Mackinac Center.
Thank you, Mr. Chairman. Can you hear me?
We can.
Excellent. Thank you very much for having me, members of the committee. Thank you very much for taking up this incredibly important issue. My name is Steve DeLee. I'm Director of Transparency and Open Government here at the Mackinac Center for Public Policy. We're a 501c3 organization dedicated to advancing policies to help Michiganders thrive. I also serve as the Executive Director of the Michigan Coalition of Open Government, which is a broad bipartisan coalition, many of which have members are here today, in support of greater transparency in Michigan. As the committee has heard, we are one of 2 states in the nation without access to records from both the governor and the legislature. I think this is a key part of why we are consistently ranked one of the least transparent states in the nation. And I'm very happy to support both of these bills today, which finally move us in the correct direction towards greater transparency. I, like Lisa, have a few concerns here regarding some of the exemptions, but I think they can be largely summarized as thusly. The existing exemptions we have in FOIA cover a broad variety of topics. They address privacy, social security numbers, security concerns, frank communications between elected officials prior to making a final policy decision. I think if you look at those exemptions and how the courts have applied them, generally speaking, they cover a lot of what the exemptions before you today are concerned with addressing. That said, one of my big concerns in particular is the exemption in Section 13M, which is the frank communications exemption. That's a fairly broad exemption. And right now, for other public bodies, the way that works is the public body has to show that the interest in encouraging frank communications between elected officials or appointed officials is greater than the public interest in accessing those records. The exemption in here kind of flips that default and results in an inverse test. So I have particular concerns with that exemption, but a more broad approach I would recommend would be review the existing exemptions and see which of the new exemptions might already be covered by those. I do recognize the need for some unique exemptions for both the governor and the legislature. Both branches have unique constitutional duties. And when an exemption relates to those duties in such a way that it doesn't relate to a more general public body, I could see the need for that. I just encourage looking at those closely with an eye towards what have we already addressed in existing law. That said, we are fully in support of these bills. They're a great step in the right direction. I think it will meaningfully advance transparency here in Michigan. And I'm very thankful to the committee and to the bill sponsors for taking up this issue. I think it's a bipartisan issue, and I think it's an issue that can really benefit the lives of most Michiganders. With that, I thank the committee for its time, and I'm more than happy to answer any questions.
Okay, Senator McBroom, you have a question or comment?
Thank you, Mr. Chairman. And I know Ms. McGraw brought this up as well, with the 30-day holding of documents, the possession of, and if I recall a lot of the calculation from this correctly, it has to do with the fact that as policy issues can come forward, particularly if we're really in a heated time where we're passing lots of bills, a tremendous amount of amendments, substitutes can be introduced in a very short amount of time. Analyses are flying everywhere. I mean, you create a huge amount of documentation for 5 different subs only to adopt the 12th one. And the issue was, how do we possibly manage to keep hold of all of this various documentation that's flying around, some of which never even gets read because they've already moved on to the next thing. You feel bad for the staff person who had to write it, only to change it again. And so this was, if I remember correctly, as Senator Moss and others, and I worked on this, it had a lot to do with just how can a FOIA coordinator possibly ever facilitate some of these documents that are so rapidly produced and dismissed in short order. And so I think that's what we were trying to do. And so certainly respect the fact that it looks strange and people are trying to figure out what it is, and certainly open to ideas on how to handle that problem. But it is a real problem. I mean, we could be bogged down in FOIA requests for a year trying to puzzle through all of the various documents that were produced in one of those fast-paced moments. Thank you, Mr. Chairman.
Thank you. Seeing no other questions, thank you very much, Steve. We'll go on to our next person who wanted to testify, Kim Murphy-Kovalik from Voters Not Politicians. Kim, are you with us on the Zoom?
Yeah, I'm sorry.
Okay.
I thought I was after the ACLU. Okay. My name is Kim Murphy-Kovalik, and I am the Programs Director at Voters Not Politicians. Thank you, Chair Singh and members of the committee for giving me the opportunity to speak today. And thank you to Senators Moss and McBroom for your diligence and perseverance in sponsoring these bills. I'm here to support Senate Bills 669 and 670. On behalf of Voters Not Politicians and the 8,000 people who have volunteered with us all over the state of Michigan, I want to speak in support of expanding the Freedom of Information Act to the legislature, the governor's office, and the lieutenant governor's office. Openness and transparency are pillars of a strong democracy, but Michiganders are currently restricted from viewing key information that would illustrate the vital function that you serve and that the governor's office serves, how policy is shaped. The decisions made here impact every aspect of our lives, for better or for worse. This policymaking process is shrouded in secrecy, and we, the people, deserve to know who is influencing policy decisions and why some policies move forward while others stall. The discourse surrounding these decisions is important context for a full understanding of the outcomes produced by this esteemed public body. Voters entrust public officials to faithfully represent their interests, the public interest. Maintaining openness will ensure that that trust is not broken. While Senate Bills 669 and 670 go a long way to closing loopholes left in 1977, there is a specific section of 670 which creates a different set of circumstances for the legislature and the governor's office in regards to exemptions. Under existing FOIA law, if an individual brings a lawsuit to compel disclosure of information that has been withheld by a public body, this is a quote, beginning the quote, "The court shall determine the matter de novo, and the burden is on the public body to sustain its denial," end quote. The amended section 13M of SB 270 provides that as to the governor's office and legislative public bodies, the exemption of communications and notes within a public body or between public bodies does not apply if, in the particular instance, the public interest in disclosure clearly outweighs the public interest in encouraging frank communications. As to all other public bodies, this exemption does not apply unless the public body shows that in the particular instance, the public interest in encouraging frank communication between officials and employees of public bodies clearly outweighs the public interest in disclosure. To put it more plainly, under the existing FOIA law, the presumption is in favor of transparency and disclosure, and the public body seeking to withhold information has to carry the evidentiary burden that secrecy is clearly required. Under this proposed bill, the legislature and the office of the governor enjoy a presumption of secrecy as to these notes, and the public has the heavy burden of proof that disclosure is clearly required, a burden made even more difficult by not having the actual content to demonstrate why disclosure is required. Placing this heavy burden on the public and establishing a higher level of secrecy for the legislature and the governor's office is entirely avoidable. I hope this committee will consider an amendment that corrects the issue. I'll conclude with a suggestion born out of research by members of VNP's Policy Committee for improving the administration of FOIA. I think this will speak to Senator McMorrow's concern expressed earlier. Our state's current administrative structure for the processing of FOIA requests is fragmented and difficult to navigate. Separate offices within each state agency are overwhelmed with requests, sometimes leading to backlogs. No administrative body exists with enforcement or mediation powers, and only media outlets and well-funded organizations are able to appeal FOIA denials. Judicial review is the primary enforcement mechanism, but litigants are constrained by lengthy waits and the hefty costs of legal counsel. To reduce the roadblocks which inhibit public utilization of FOIA, we recommend the formation of an independent state FOIA ombudsman office, which reports to a FOIA oversight commission. At least 20 states have established FOIA ombudsman offices, and 12 states have created enforcement commissions. We can establish both of these offices, the office and the commission, using successful models from states such as Connecticut, Iowa, and Maryland. The Ombudsman Office would educate the public on how to navigate FOIA and draft more precise FOIA requests, conduct training for public agencies on processes for effective compliance, provide mediation services to resolve disputes, and other valuable services that will enhance the administration of FOIA. Thank you so much for your time. And thank you again, Senator McBroom and Senator Moss.
All right, thank you. Any questions for this organization? Yep. Senator McBroom.
Thank you, Mr. Chairman. Thank you for your comments. Do you have them in writing?
I do, yes.
Okay, I'd like to have a copy of it, if I may. Thank you.
Sure.
Okay, we'll make sure that if you get that to the committee, we'll make sure that gets out to members to be able to take a look at some of the suggestions you've made. All right, thank you very much. Our next speaker is Marissa Kovac from the ACLU.
Good morning, Marissa Kovac, Legislative Director with the ACLU of Michigan. I'm very excited to be here today. Thank you, Chair Singh, for bringing up this important legislation. And thank you always to the bill sponsors, Senators McBroom and Moss, for championing this for so many years. The ACLU is an organization that values transparency and the right of citizens to have accurate information about their government. Is very excited to support Senate Bills 669 and 670 today. We are also a member of the Michigan Coalition for Open Government, so in the interest of time, I've submitted my written statements. I also, we are aligned with the points made by our colleagues within the coalition, the Mackinac Center, and the Press Association as well. So I would just like to echo, though, that we agree that Michigan's laws around transparency and accountability as it pertains to the bodies covered under these bills is abysmal right now, but this is a really good first step that we urge you to take. This package has been a really long time coming. One area that we do think, there are a few areas that we think could stand to be improved for transparency. Just one area I'd like to comment on that I feel like the ACLU is particularly poised to do so is around constituent communications. As an organization that highly values personal privacy for all Michiganders, I have a great deal of respect for why the intent of having that exemption in the bills is there. We do think that there is a way of striking a better balance between ensuring constituent privacy and especially sensitive personal information and ensuring transparency and constituent communications, given that some of those communications may involve legitimate issues of public purpose. FOIA does have a privacy exemption for personal information. We would be supportive of adding some elements of that specifically into this bill, but we are concerned that that blanket exemption for all constituent communications is lacking there and doesn't strike exactly the best balance that it could. Given that, though, I know that these bills are a product of a lot of negotiation and problem solving with a lot of different parties over the years, so we're in full support and excited to hopefully see them through the finish line this time around, and happy to answer any questions.
All right, any questions? We'll start off with Senator McMorrow and then Senator McBroom.
Thank you, Mr. Chair. Thank you so much for addressing that concern. Just a quick question, because I think something that Senator Moss pointed out that we see a lot is constituents reaching out to their legislator or our office out of desperation. It is the last result. They've tried, 20 different things. They're in crisis. And I think that initial outreach is something that our staff in particular are concerned about protecting. If there's then training or understanding from the staff perspective on how to respond to that constituent, would that be something the ACLU might consider as, that initial outreach is protected? Because we don't want to penalize regular residents of Michigan in a moment of desperation who may be oversharing or sharing information, or even just not even their personal information, but details about their circumstance that they wouldn't want to be made public.
Yeah, certainly. I think we'd be open to that conversation. Certainly steps to ensure that names, personal identifying information is redacted, I think are places where the conversation could move to and start to ensure that folks' personal privacy, especially when they're reaching out and they're deepest moments of need and possibly divulging personal information, that's protected. That's something that we truly respect and value and would want to problem solve.
Thank you very much. And to the bill sponsored, I'd love to help keep working on that because we've seen a lot of really devastating circumstances, and I want to make sure constituents know they can reach out to us and wouldn't see this and think that they can no longer do that.
Certainly.
Senator McBroom and then Senator Geis.
Thank you, Mr. Chairman. Thank you for your remarks. I guess I'm trying to, could you help me understand what you're concerned about finding within communications with constituents? I mean, you're the first person I've ever had come forward who's unhappy with the exemption for constituent communications. And so, I look at what I get from constituents. The cases as Vice Chair McMorrow referenced, the people who send me a note saying, thank you for voting this way, you're wonderful. The people who send me a note saying, I hate how you voted, you're the worst thing that's ever happened. The people who say, please vote yes on this and help my local library. People who say, please vote no on that. I mean, I'm having a hard time understanding what you're what you're suggesting could be looked for and would be hidden by providing exemption to constituent communications.
I think to that point, though, is if that's largely the communications, and why not shine a light on it? And I think I think we could pull some examples from recent history on potentially where folks may want to see how their elected officials are interacting and responding to their constituents and their communities, especially because the policies that you're passing may very well be felt at the local level, and there may be signs of those policies or actions by government being felt and started at the local level. For example, if we want to look at recent history and hopefully that this history doesn't repeat itself, but in an instance like the Flint water crisis, if you consider that the impact of that was being felt at the local level, should a situation like that happen again, you all may be some of the first to hear from your constituents about it. And then, in the look back that was done around the Flint water crisis to identify where did things fall through the cracks? Why was this not caught earlier? That could be important information for the public to understand, as where were whistles being blown? What were the first signs so that a crisis like that doesn't happen again? So just like one example, and not saying that was a situation that happened around the Flint water crisis, but where matters of public interest very well could start at the local level and be communicated to your offices. That I think this is like where we're getting at, is where we would want to shine a light onto, while still, of course, maintaining personal privacy of constituents who reach out to you.
Well, I guess I'm missing something in communication, because I really not understand, even in the Flint situation example, how letters to the reps from Flint at that time, why would somebody be searching, and how would they search for those letters, and what are they looking for that we can't get from what we are providing, where it says you can FOIA the office and say, how many times did you communicate with the executive office? How many times did you communicate with DEQ on behalf of your constituents regarding the Flint situation or some other situation? But those letters between me and my constituents, I'm not hearing a compelling case to change that, so thank you.
All right, we'll go to Senator Geis.
Thank you, Mr. Chair. I think that regarding the constituent communications, as someone who's worked on, in conjunction with the ACLU, legislation that protects the privacy of residents, especially who are going through very particularly vulnerable situations, I think we need to be very careful and extra considerate about protecting the privacy of our residents, especially when their situation might be one where even if you redacted names and addresses and identifying numbers, the situation itself could still yield being like, oh, I know who that person is because of that story. That's that storyline. And I say this with great intentionality, especially as being one of the two legislators in this room who's against NDAs, for example. And that is really sensitive stuff, and we don't want to end up causing harm. And yes, I understand the need and the desire for people to to have all the information possible. But we shouldn't be doing it at the expense of like our literal bosses, the very people who send us here to do this job. So I caution like trying to weaken the exemptions for constituent communications.
Okay. Well,
Okay.
sorry.
Thank you.
Sorry, Senator Lindsay. Yeah, we got time.
Just on this topic of the constituent communications, another concern I have is at least when we're talking about how our offices communicate with other parts of government, that's on us, and so we can look into that. On the constituent side, I would have a concern that it's not all organic traffic, right? Like we see this all the time in our offices where we get a blast of emails, and then I sit there and call a bunch of people back. They don't answer. Figure out that was not, or I talk to them. I say, "Are you a constituent in my district?" And they're like, "No, somebody in somewhere else told me to do this. I don't even live in Michigan." So one of the problems I'm pointing out is that if you go allow all that inside FOIA, people can then sort of engineer phishing expeditions to say, we send a bunch of stuff to an office and then we do a gotcha by FOIAing that information and say they didn't respond to it appropriately or anything like that. So it's just another angle of concern, I think, of we don't control what kind of outreach comes to us, and we can do our best on all the organic constituent outreach that happens, but we can't control what all goes through those boxes. So I'd be concerned about that as well.
Yeah, if I may, I think we're also relying on language that's like trying to support some language and standards are already within FOIA. Privacy provisions are already in FOIA with the intent of protecting personal, private information that is coming from constituents, and that there are other government bodies in the state who have constituents that they may be hearing from who don't have this exemption. So I think all we are suggesting is that rather than a blanket policy, is there a way that we can go in with a scalpel to try to shine a little bit of light to ensure that those correspondents that may have a true, genuine public interest, there's a light shown on that, while still maintaining this deeply personal information that constituents may be divulging to you.
Right. Thank you. Well, those are the people who asked to speak. There are a series of cards, and the clerk will read those in.
Judy Karenjeff, League of Women Voters from Michigan, supports both bills. Denzel McCampbell supports both bills. Jim Tarvant with the Michigan Press Association supports both bills. Mary Polak, Michigan State Employee Retirement Association, supports both bills. Liz Kirkwood for the Love of Water supports both bills. Jim Schaefer, Detroit Free Press, did not note a position.
All right. Well, this is obviously our first opportunity for testimony. I know both sponsors have said that there will be continued work on this, as well as some workshopping on this information, and I look forward to continuing to work with them over the next weeks to see if we can finalize some of this, and we'll bring it back to the committee when that work is ready. So I want to thank everybody again. We do have other items on the agenda, and let's move to those. 2 weeks ago, we heard testimony on Senate Bill 692 through 695. Those are bills that were brought forward by Senators Klinefelt, Kavanaugh, and myself. Based off of the Auditor General report on findings within LARA regarding camps that are regulated by them. There are some substitutes for 692 and 694, and they're minor, but let me just share with you what those are. In 692 and 694, MSP had requested that we add a little language to the criminal history check to include latent fingerprint searches as part of the definition there, and that is changes that happen now in 692 and 694, and then as well in 692, the sub clarifies that we're talking about the state's automated fingerprint identification system. Again, minor changes brought to us by MSP to just clarify the definitions. Doesn't change the intent of the legislation. Any questions before I ask those substitutes to be approved? Seeing none, clerk, are there any other cards on these bills that are that we haven't read in?
No, Mr. Chair, there are no cards.
All right, then we will take a look at the substitutes. I'll entertain a motion to adopt the Senate 1 version of Senate Bill 692. It's been moved by Senator Geis. Will the clerk please call the question?
On adopting the S1 for 692, Chairman Singh.
Yes.
Senator McMorrow.
Yes.
Senator Geis. Senator Palanky. Senator McBroom.
Yes.
Senator Lindsay. Mr. Chair, there are 6 yeas and 0 nays. The substitute is adopted.
I'll also at this point entertain a motion to adopt the S1 version of Senate Bill 694. So moved by Senator McBroom. Will the clerk please call the question?
On adopting the S1 for 694, Chairman Singh.
Yes.
Senator McMorrow.
Yes.
Senator Geis. Senator Palanky. Senator McBroom.
Yes.
Senator Lindsay. Mr. Chair, there are 6 yeas and 0 nays. Substitute is adopted.
Thank you. At this point, I'll entertain a motion to report Senate Bill 692 as substituted to the floor with recommendation that the bill will pass. So moved by Senator McMorrow. Will the clerk please call the question?
On reporting 692 as substituted, Chairman Singh.
Yes.
Senator McMorrow.
Yes.
Senator Geis. Senator Palanky. Senator McBroom.
Pass.
Senator Lindsay.
No.
Mr. Chair, you have 4 yeas, 1 nay, and 1 pass. The bill is reported.
Thank you. At this point, I'll entertain a motion to report Senate Bill 693 to the floor with recommendation that the bill pass. So moved by Senator Geis. Will the clerk please call the question?
On reporting 693, clean, Chairman Singh.
Yes.
Senator McMorrow.
Yes.
Senator Geis. Senator Palanky. Senator McBroom.
Pass.
Senator Lindsay.
No.
Mr. Chair, there are 4 yeas, 1 nay, and 1 pass. The bill is reported.
Thank you. At this time, I'll entertain a motion to report Senate Bill 694 as substituted to the floor with recommendation that the bill pass. So moved by Senator McMorrow. Will the clerk please call the question?
On reporting 694 as substituted, Chairman Singh.
Yes.
Senator McMorrow.
Yes.
Senator Geis. Senator Palanky. Senator McBroom.
Pass.
Senator Lindsay. Mr. Chair, there are 4 yeas, 0 nays, and 2 passes. The bill is reported.
I'll entertain a motion at this time to report Senate Bill 694 to the floor with recommendation that the bill will pass. So moved by 695 to the floor with recommendation that the bill will pass. It's so moved by Senator Palanky. Will the clerk please call the question?
On reporting 695 is introduced, Chairman Singh.
Yes.
Senator McMorrow.
Yes.
Senator Geis. Senator Palanky. Senator McBroom.
Passed.
Senator Lindsay. Mr. Chair, there are 4 yeas, 0 nays, and 2 passes. The bill is reported.
All right. Being that there's no further business in front of the Senate Committee on Oversight, we are now adjourned.